So it's been a momentous 24 hours. The Speaker of Parliament yesterday informing the House he had declared 4 seats of 4 MPs vacant, pursuant to a statement that was made on the floor by Dr. Kassie Latofos, the minority leader, who perhaps became the short-lived ever majority leader because his reign as majority leader did not even surpass 24 hours before the Supreme Court of Ghana, unanimously, 5-member panel, presided over by Chief Justice Gertrude Tokono, stayed that ruling by Alban Bagbin yesterday. Or, as some have said, it wasn't a ruling, just an information, staying the decision by Bagbin to declare 4 seats vacant. The Supreme Court is clear that this order will subsist until the final determination of this matter. Tonight on Ghana Connect, we divert this big news and some information that we have and then discuss around the panel.
I proceed to inform the House that by the notification of the polls, the following members of Parliament have by their actions vacated their seats in Parliament.
Yesterday, Mr. Speaker did his worst. But we are not perturbed by all these because clearly Mr. Speaker wants to be in the good books of his party. He wants to remain Speaker again for a second term. So he wants to be seen as having helped his party.
We have the working majority. Right, Honorable Speaker, beginning the next parliamentary sitting, will begin the process to take over as the majority caucus of this.
So where do you stand? Do you agree with Alban Bagbin, who declared those 4 seats vacant, and all the issues that have come up since the majority side, the NDC, NPP, making a meal out of this, and the latest decision by the highest court of the land? When I come back, I have some brilliant minds connecting on this important matter. We are about to be educated. Stay tuned. Don't go anywhere after this.
You see them. You see them every day in our communities, doing what they do best to make a difference in the lives of people. You see them. You see them bring positive transformation to the lives of people in the areas of education, health, and economic empowerment. While many will see them and turn their faces away, you see them. You see their efforts, and you know they're heroes who deserve to be celebrated. MTN Heroes of Change is setting out to unearth and to celebrate a new set of heroes. You can throw the light on the heroes you see in your community by nominating them to win 100,000 Ghana cedis and other prizes to help them expand their work. Just fill an online nomination form at mtn.com.gh or send a WhatsApp with a 1-minute video of your nominee's project on 055 141 1122. Deadline for nominations is 18th October 2024, so don't waste time. Nominate your hero now. MTN Heroes of Change. Be the change you wish to see.
Son, we are so proud of you for setting up this hospital. I really love those hospital beds and waiting chairs. By the way, did you import them?
No, Dad, I didn't. I actually got them from Kingdom Books and Stationery right here in Ghana.
Wow. We also bought our office supplies, safes, executive desks and chairs from Kingdom, and they gave us expert advice on how to set up our office.
Guys, that makes 3 of us. I also got our sofa and bedroom sets, plus our dining hall furniture for our new home from Kingdom.
Wow, Mom, that makes 4 of us. I usually get my stationery items from Kingdom, and my teacher also mentioned that our classroom furniture was provided by Kingdom.
So there you have it. Whenever you're thinking about setting up an office or acquiring furniture for your home, etc., Kingdom Books and Stationery should be your first point of call. With over 40 years experience in the industry, we stock and supply a wide variety of globally sourced office and home furniture, stationery and equipment. Visit our head office, Osu Akwaje, or our office near the Osu Stadium. We're also in Tema Community 1, opposite Olam SHF, Kumasi KNUST campus, UCC Cape Coast, and now at the Marina Mall, Airport City. Or call us 0302 764101, 764209, or 762792. Visit our website www.kingdomgh.com.
Hey, we have a new leader in town. Obiarentie. Amanfo, Madam was Sibebre. When him say my baby, maybe more charcoal for whiter teeth. More charcoal. Not only that, maybe lemon. More lemon. Zinc for fresher breath. More zinc. And fluoride for stronger teeth.
Introducing the new President Charcoal Pack with more power with a combination of charcoal and lemon for naturally whiter teeth. Grab yours now. This advert is FDA approved.
Attention CEOs, join Ghana's top 1,000 CEOs, policymakers, political leaders, and ambassadors for the first Ghana CEO Presidential Manifesto Gala Dinner 2024 on November 7, 2024 at the Mervyn Pig Hotel, Accra from 6 to 10:30 p.m. This historic event will focus on reigniting the business economy and social contract for growth, a business manifesto for political accountability and sustainable development. Special guests of honor include His Excellency Dr. Mahamudu Bawumia, Vice President of Ghana, and His Excellency John Dramani Mahama, former President of Ghana. Attendance is by invitation and requires pre-registration. Register at ceogaladina.conetworkgh.com. For inquiries, contact 0546391970 or email ceogaladina@gmail.com. This event is powered by Chief Executives Network Ghana in partnership with Deloitte, PwC, University of Ghana, SIGA, GIPC, UPSA Law, and the Multimedia Group. The first Ghana CEO Presidential Manifesto Gala Dinner 2024, connecting political ambitions with business realities.
Charlie, this year's elections, I am really confused. I don't know who to vote for.
Why don't you know who to vote for? Let's listen to one policy JDM says he's going to implement when he's voted.
I think so NDC ban. You be bien Juman kitten. My person branch executive na di omo be gym. Say yankuko na person share poultry farm ketue bi near mao akuko bono near ton kuko na mao near mao eduane a wo de beto eduane sika wo de beto eduane ama.
But why are you laughing? My guy, relax. So this is the reason he wants us to vote for him? Oh, the man hasn't changed one bit. Same old dead goat. Now let's listen to one of the many policies Dr. Bawumia has for the youth.
Jobs would be my major focus. Now, me be training 1 million youth in digital skills.
And see, that's not all. Apart from that, he's going to set up SME Bank to enable SMEs expand, to create jobs for the youth, and also increase demand with the buy now, pay small policy, which is the credit scoring system.
Oh, really?
That's not all. Let me give you the last one. He says he's going to introduce Buy Ghana First policy to boost local businesses to help them expand and employ more youth.
Wow. Now, I know who I'm voting for come December 7th. Dr. Bawumia, you have my vote.
Yes, so these are but a few of DMB's bold solutions for the youth when he's voted into power come December 7th.
I've changed my mind. I'm not voting for JDM anymore. I'll vote for the bold solutions man, Dr. Bawumia.
Great decision, my brother. This year, Dr. Bawumia's vote, yem fan cheche.
And
Vote Dr. Bawumia, number 1 on the ballot.
Imagine having access to top-notch educational resources, no matter your grade of school or location in Ghana. With the Ghana Knowledge and Skills Bank, you can tap into a vast library of resources, even in offline mode. From primary all the way to tertiary education, we've got you covered. As a student, you have access to past questions from 1990 to date for BEC, WASI, and tertiary test examinations. As a teacher or lecturer, you can hold virtual classes for your students and share your lecture notes for their use. As an educator or researcher, you can publish your books or articles for public consumption. And lastly, you have your own studies teacher or AI tutor who is trained to teach you in any subject topic till you fully understand. So whether you're a student, educator, content creator, researcher, or entrepreneur, the Ghana Knowledge and Skills Bank was made just for you. Sign up today at www.gksb.gov.gh. The Ghana Knowledge and Skills Bank, where learning has no limits and the possibilities are endless. This project was financed by the World Bank under the erstwhile e-Transform project at the Ministry of Communications and Digitalization.
Welcome back to Ghana Connect. My name is Kwaku Asante. For those of you listening and unable to join us, please do send us your text. We'll be ready and willing to listen to you. 055-1111-997, 055-1111-997. Send us a message on WhatsApp and let us know what you think. Do you agree with the decision by the Speaker? Or what do you also make about that ruling that was handed down by the Supreme Court moments ago? But for those of you who are not really familiar with all the issues, this is how all the issues have gone down.
Voters elect a candidate. They do so based not only on the individual's personal qualities, but also on the political party platform they represent. Accordingly, I proceed to inform the House that by the notification of the polls, the following members of Parliament have by their actions vacated their seats in Parliament. Are you?
A conspiracy between the Speaker and the minority to bring confusion in the House. It is clear that Mr. Speaker avoided service of the writ to do the bidding of the NDC. The majority caucus immediately are boycotting Parliament until this matter is determined by the Supreme Court.
We have the working majority. Right, Honorable Speaker, beginning the next parliamentary sitting will begin the process to take over as the majority caucus of this parliament.
Yesterday, Mr. Speaker did his worst. But we are not perturbed by all these because clearly Mr. Speaker wants to be in the good books of his party.
Well, those were some of the strong words that were used by the majority leader, Alexander Afenyo-Markin, whose majority leadership is now no longer in dispute. As of yesterday, he no longer was the majority leader because at the time the Speaker made the ruling, the NPP had 135 and the NDC had 136, which clearly meant that the NDC were a majority. But now, the Supreme Court has put all that beyond doubt for now, at least until the determination of the final matter. So, what do you make of this? Let's connect on these important matters. David Kratos is a lawyer. He's been following these issues. He has some very important views to share on this and is connecting with us in studio. David, it's good to have you connect and making your debut on the show.
Good evening.
Timothy Selikem Donko is connecting with us on Zoom. Timothy, it's good to have you connect with us on this matter. If you can unmute.
Yeah, good evening, and I'm most grateful for giving me this opportunity.
Idi Muhayuddin is also a political communicator. He is really well known within the NPP circles and is connecting with us on this matter. Idi, it's good to have you connect with us. You have to unmute, Idi. Right.
Hello.
Yes, yes, it is good to have you. And then Julius Yao Petechi is a veteran parliamentary reporter. He reports for the Ghanaian Times and is connecting with us on phone. Julius, it's good to have you connect with us. Hello, Julius. Well, I'll get Julius pretty shortly on there. But let me start with you, David, in studio. David, where do you stand with that decision that was made by Alban Bagman yesterday?
Well, good evening once again. So the decision by Alban Bagman yesterday raised very interesting political developments. Very interesting times in this eighth parliament where we see a lot of drama happening. Ideally, I think the Speaker was right to make the decision based on the precedents available to him, how the matter had been handled in the past, and what constitutionally was before him.
There are those who've made matters about natural justice and all those things. Don't you think those were important? And that, or you don't think they apply in the system?
Oh, well, indeed, yes, they do apply. They do apply. Indeed, you should have heard them out. But then I believe the speaker made copious references to the fact that a notice of poll was issued by the EC. And by that notice of poll, you could see that these members of parliament had either or had in one way or the other moved from their political allegiances towards another political allegiance, which a situation Article 97 of our Constitution does not allow or does not support, because Article 97 sees that as cross-carpeting. So immediately a member of parliament decides to move from the party he was elected to parliament on, or decides to become an independent candidate, then that person automatically vacates his seat by the provisions in the Constitution. As Speaker and as person in charge of the parliamentary business, it was in his place to now institute what the constitutional provisions were saying. And so in the event of any disagreement with how the Speaker applies the Constitution, then other avenues may be sought. Like we saw now, the Supreme Court has made a ruling on whether or not the seats should be vacated. The Supreme Court says the seats shouldn't be vacated, and that's where we stand now.
I mean, Idi Muhaidin, that is opinion of David here in studio, that, listen, the Speaker, it appears to him, was right in the determination he made yesterday. Of course, we'll get into the Supreme Court decision later, but where do you also stand on that? Hello, Idi, can you unmute?
Yes, okay. Is it clear now? Can you hear me?
I can hear you loud and clear.
Okay, so for me, the crux of this matter really border on constitutional interpretation. And if you like, because clearly what the Speaker sought to do was to clearly interpret the Constitution. Because you and I know very well that when it comes to the matters that the Speaker, both parties were raising, if you like, well, they were giving rival means to constitutional provisions. The decisions of the court, as part of proposal, clearly when the rival means are placed on constitutional provision, then automatically that interpretation obviously can only be given by the Supreme Court and not the person before whom the issue is brought. So my contention really is that the Speaker, what he had done was clearly to assume jurisdiction, which he does not have, to interpret Article 97. That is one issue. That is one leg I have seen. Then the other issue that I have difficulty with is clearly when you look at the provisions of Article 99. When it comes to making a determination as to, if you like, whether a member of Parliament really is in Parliament in accordance or vacates his seat, or whether really he's supposed to be in Parliament, clearly that particular determination can only be done by the High Court.
I mean,
that is the wording of Article 99.
Great. I mean,
and it's not the place there for the Speaker.
Okay, yes, I can hear you. Please hold it there for me. I can hear you. Please hold it there for me. Selikem, where do you stand on that? He said what the Speaker purported to have done yesterday was interpretation, which was not in his purview to do, but that of the Supreme Court. Do you agree?
Yeah, so I think there is a need to make some clarification and correct some erroneous assumptions or opinion with regards to that. Now, with the issue of interpretation of the Constitution, Article 130 deals with it. Now, the position of the law is that if any question of interpretation of the Constitution comes before any court, the proper court to make or to perform that function is the Supreme Court. It is never the position of the law that if rival meanings are placed before any administrative body or authority, it needs to stay its interpretation of the matter and refer to Supreme Court. That is not the position of the law. So you remember in the Saul matter, there were rival meanings that were placed on Article 49 on what should probably be done when there is a new demarcation and all that. But the Electoral Commission went ahead with its own interpretation. Now, if you have a contrary meaning to what the Electoral Commission had adjudged the meaning of Article 49 to be, then you should proceed to the Supreme Court to challenge it. Or if that matter had come before a court other than the Supreme Court, then the court by 132B is required to refer the matter to Supreme Court. So it is never the position of the law that administrative bodies or quasi-constitutional bodies should stay interpretation or application of constitutional provisions whenever rival meanings are placed before it by.
It appears I have some challenge with the Zoom connection there. I'll fix it. Selikem Donko was making a point. Do I have Selikem Donko back? Selikem, can you hear me? Right, we'll fix the connection and bring Selikem back. But Julius, we've been hearing a lot of law around this table. You are the only layman on the around the panel now. Where do you? You've been reporting from Parliament. You were there when Speaker Okwe said that precedent in 2020. Bagwin did not rely on that. He did say that it wasn't binding on him, but went ahead to give a ruling that was literally almost the same. Where do you stand?
Kwaku, good evening to you and then to listeners around the globe. Thanks for having me, and then good evening to all the colleagues on the panel. I think first and foremost, we have to understand how Parliament operates. Parliament operates with what we see, or we have always said to be precedents and conventions. So in 2020, the New Patriotic Party petitioned the Speaker of Parliament, the Right Honorable Aaron Michael Kwei, as he was at the time, that one of their own has left the party to contest as an independent candidate, and that on the basis of that, decision by the then member of Parliament for Mina to leave the NPP to contest as an independent candidate, the Speaker declared his seat vacant. So let's ask ourselves, on what ground was the seat declared vacant? Because the NPP said the MP at the time had left the party. So let's look at the NPP's constitution itself. The constitution says once you contest as an independent candidate against the established political party, you have forfeited your membership. It's straightforward. The NPP constitution is straightforward. Once you have left the party, you don't have any protection by the party anymore. So on that ground, Okwe declared the seat vacant. For if anybody is out, let me read to you a portion of what Okwe said in November. This is what he said, and I quote: "With all intent and purposes, he, that is the honorable member of Mina, is no longer a member of the party. He has pronounced himself publicly as an independent and has filed his papers to contest against the party as an independent candidate on December 2020. He continues, having forfeited the membership of the NPP. How did he do that? Did he go and tell the party that I am no more a member? No. But by the virtue of just contesting as an independent candidate, he has forfeited his membership. He continues. The Right Honorable Michael Kwei continues. Having forfeited the membership of the party, other entities, on whose ticket he was elected to Parliament, the operative language of the Constitution is that he shall, which is mandatory, vacate his seat in Parliament.
So, Julius, we have a little bit challenge with your network. It keeps breaking it and all that. We heard the substance of your point. Please position yourself well. I'll come back to you again. Eddie, you hear Julius make this point, citing the precedent that was set by Michael Quay in 2020. Was Michael Quay doing interpretation when he did that? And how do you say that Bagbin was then doing interpretation when they were simply doing the same thing, literally trying to apply the dictates of the Constitution? Because if we were to hold that what they did was an interpretation of the Constitution, wouldn't every person trying to apply the Constitution be purporting to interpret what the Constitution mean and then based on that acting on it? Hello, Idi Muhaidin, can you unmute?
Hello, okay. I want us to appreciate the thin line between interpretation and application of the Constitution. You see, when the constitutional provision is so clear and no interpretative issue arises, that is, no rival meaning is placed on it. Everybody is entitled to apply it. Everybody is entitled to apply it. Once nobody has raised an issue with it, so long as it is clear, but immediately an issue of, if like, rival meaning is placed on it. You remember the decision in Richard Anami, even the word complaint, just the word complaint alone, because the parties had placed rival meanings on it. The Supreme Court, Jojina, held that complaint was ambiguous. Why? Because rival meanings were placed on it. So the position of the law is that where the provision is so clear and no rival meaning is placed on it, then an interpretative issue does not arise. Anybody can apply it. But in this particular instance, you have a situation where the majority is saying one thing, minority is saying another thing. Then automatically, ex parte acosa, this is certain law. And I'm not sure any lawyer would debate this.
Idi, what would that mean for practical governance? Wouldn't that mean that whenever anybody raises an issue, all the other person will have to do is to raise what they call a rival meaning? And every time we have to go to the Supreme Court, we have to stop whatever we are doing in Parliament, saying the executive or whatever everybody is doing, and go to the Supreme Court. Every time somebody raises what they say to be a rival meaning, then we have to go to the Supreme Court, even when some provisions are just what it is.
So you deal with case by case issue. So the point I'm making is that in this particular instance, so of course the person before whom these if like conflicting positions are made, we also have to exercise discretion. So if you are not sure of what exactly it is, then your forum is the Supreme Court. Because my brother, if you don't do that, then I can tell you that the Supreme Court will have nothing to do in terms of its interpretative jurisdiction. It can never be invoked. It just can never be invoked, because if contentions do not happen, people do not raise rival meanings on constitutional provision that will warrant the invocation of the Supreme Court's jurisdiction, then the Supreme Court will never be called upon to interpret anything. That's just the point I'm making. But regarding maybe I want to address the bit about the NPP constitution. A lot of people say that they have automatically forfeited their membership. I have a different, if you like, understanding of the situation. I have worked closely with the party.
But doesn't the Constitution specifically state that
no,
the person will have
it
automatically?
It doesn't. Listen, the constitutions are supposed to be read as a whole, every legal text. Now, if you take the NPP constitution, you go to Article 3.9, it talks about forfeiture. Now, beyond Article 3.9, now you don't read Article 3.9 alone and apply it. Now, you go to Article 3, so you go to Article 3.3. Article 3.3 on rights of members. On rights of members. It says that no decision shall be taken until the member is given a fair hearing, until the member is heard. And that aside, then you go to Article 4.3.6. It says a member who breaches any provision of this constitution, if you have the NPP constitution, you can refer to Article 4.3.6. It says a member who breaches any provision in this constitution or whose activities undermine the party's constitution shall have a complaint lodged against him. Now, essentially, these provisions, what these provisions seek to achieve is to conform with the general principles of natural justice. So that when an issue is raised that Cynthia Morrison has breached the NPP constitution because she has declared intention to contest as independent, the party does not automatically assume or deem her as having left the party. She must be heard because even she has breached the constitution, and the constitution says that a member who breaches any provision of the constitution shall have a complaint lodged against. So the point I'm making is that that conversation that talk about automatic forfeiture, we must hasten slowly. And that's the reason why the Speaker of Parliament, and you also know that in the NPP constitution, the National Council of the party has the constitutional mandate to actually vary any provisions of the constitution.
Okay, I see the point you're making, and I think we would come there when we're about to tie that in with the Supreme Court. David, where do you stand on? Do you agree with the positions that have been canvassed by Idi Mohaide?
No, so I don't fully agree with Idi's position. So you see, he makes the point that there are rival meanings being placed, and once there are rival meanings being placed on the constitutional provision, then it is the Supreme Court which has to act. I do not agree fully with that statement because anybody could put rival meanings on anything. And once there are rival meanings, it does not in any way prevent a person who has the authority to act on a matter. It does not prevent him from acting on that matter. Rather, what the Constitution has also done is, pursuant to Article 2, any individual who alleges something is unconstitutional may go to the Supreme Court for a declaration to that effect. So to the extent that the Speaker has before him two people placing rival meanings, does not mean that there truly to the Speaker is rival meanings to be given effect to. So the Speaker can decide that to him, this is not a matter of constitutional interpretation. It's a matter of applying the Constitution, which the Speaker did lay bare when he was giving his ruling, or he was informing Parliament of his decision. So once he was applying the Constitution, to that extent, we cannot fault him, or we cannot say that because of the mere existence of rival meanings, as alleged by two different individuals, then all of a sudden the Speaker's hands are tied. Like you mentioned, for good governance, how would it be possible that whenever there are two rival meanings being placed on something, then all of a sudden it means that the body should not act again, we should hold on, anything should happen? Rather, in this case, as has happened, the Speaker gave his ruling. Now, anybody who was dissatisfied went to court, and now the court has also given its ruling, which ideally is how things should happen. It shouldn't be that just because one party says it means A and another party says it means B, then it means that we have a difficulty. Then to his second point on the forfeiture question, I believe in answering this question, we have to consider who is a member of Parliament and what does it mean to vacate your seat as a member of Parliament for leaving a certain political party. Now, he made reference to the MPP's constitution. I think on this matter, both the MPP's constitution and the NDC's constitution can offer us some guidance. The MPP's constitution seems to suggest that a member of Parliament who runs against somebody else running on the party's ticket has automatically forfeited his membership of that party, of the MPP. So I think that's with Article 3 of the MPP's constitution. So I believe that automatically that puts the MPs who have been deemed to have forfeited their seats in a more terrible position. As contrasted with the NDC, I think with the NDC, it's Article 8 of their constitution. Theirs doesn't seem to be an automatic situation. So then with that, then you make say, then okay, now that this person has forfeited, stepped away from the party to contest as an independent candidate, does that mean that in the sense of this Parliament, this person has cross-carpeted? I believe that we have to answer those questions before we can even talk about whether or not there's any automatic forfeiture as a member of Parliament or no automatic forfeiture.
Okay, so let's zoom right into the decision of the court. Selikem, I want to start from you on that. The Supreme Court did sit today, and you heard the Honorable Dafia Mekpo MP for Southeye raise questions about how the court purportedly dealt with this matter so fast and all the issues they raised. Those are some political issues. But in terms of still talking about the legalities, was the court right in going through the route of stay of execution? There are those who said that. What exactly is the order staying? The execution. What order is the court staying? What's your view on that?
Yes. So I think I would answer this in two ways. First of all, there is the question of what really is the jurisdiction of the Supreme Court and what are the powers of the Supreme Court. When you come to our Constitution, Article 130 gives the Supreme Court the power to enforce and interpret the Constitution. I understand that the originating motion that occasioned the hearing of the action was by an enforcement and an interpretation action under Article 130. Now, assuming that to be the case, then the issue arises whether or not the Supreme Court has the authority to stay an order of Parliament by virtue of its originating jurisdiction being invoked. Now, the issue here is one. When you say a court is staying an order, first and foremost, the order must be an executory order. So an order that cannot be executed cannot be stayed, right? In administrative law, in common law, it is known that all administrative orders are non-executory. It means they take effect as and when they are made. Unlike administrative orders, judicial orders of courts are executed. So when you go to a high court and you get a civil judgment in your favor, as a judgment creditor, you are supposed to execute the order. You can execute the order by facias or all other means of executing orders. But administrative orders are non-executory. So when administrative orders are made, they take effect as and when made. So there is no way a court can stay an order made by an administrative body. That is one. The second issue is whether or not, even if it is possible that a court may stay an order, whether the Supreme Court has the power. Now, the powers of the Supreme Court, in line with the orders the Supreme Court can make, has been set out in the Constitution and by CI 16, which is the Supreme Court rules. Now, for our purpose, it is Article 1294 of the Constitution that is material. I read Article 1294. It says, for the purposes of hearing and determining a matter within its jurisdiction and amendment, execution or enforcement of a judgment, order made on any matter, and for purposes of any authority, expressly or necessary implication given to the Supreme Court by this Constitution or any other law, the Supreme Court shall have all the powers, authorities, jurisdiction vested in any court established by this Constitution or any other law. Right? So by virtue of Article 1294, Supreme Court has its own powers stated in the Constitution and has all the powers of all other courts. Now, does any power or does any other court has a power to stay an administrative order of a court? No. What we know very well is that if a supervisory jurisdiction of a court is invoked, the court can either by a prohibitive order or a certiorari strike out that order. No court has the power to stay an administrative order of a court. So by virtue of the modus and the propriety of the procedure for which the Supreme Court made the decision itself is problematic. That is one. Now, on the second issue is whether or not, even if the Supreme Court has the power and a stay order is the appropriate remedy. I have engaged the conversation, I think even with Oliver before, on or what you call interlocutory orders that the Supreme Court can make in hearing cases. I have held the opinion that even the Supreme Court does not have the authority to make interlocutory orders, being injunction, to stop the functioning of any constitutional body pending determination of a case, right? And it is this reasoning that informed the court in 31st December case, that when an action was brought in court by the MPP to stop the Rawlings government from celebrating the 31st December case, the court decided not to hear the injunction application, but rather to expedite the hearing of the substantive case. Now, it stems from the issue of what? The non-suitability of what? Interlocutory orders in dealing with constitutional cases. Because what you end up doing is that you forestall the process of governance by staying the functioning of a particular body whilst a case is being determined. Now, we know that the Supreme Court is very good at delaying cases. So imagine this case takes for 4 years. It means that the Supreme Court will succeed in staying Parliament from performing its function until the case is decided. So I disagree entirely with all interlocutory process that can be used in stopping any other body from performing its function pending the determination of any case before Supreme Court.
Right. I mean, let's do the law before, then I'll come to you, Julius. Please bear with me. I'll come to you pretty shortly. Edie, do you agree with the premise of the argument that have been made forcefully by Selikem that the court's opinion today, the court's ruling today, have some questions mark around it?
I disagree. I completely disagree. What it is, my points of disagreement really very clear. Now, what the speaker has done, is it something that can be implemented? Because he had ruled that the 4 members of parliament have vacated their seats. And therefore, what it means is that when next Parliament is meeting, the 4 members of Parliament are supposed not to, if you like, make appearance in Parliament. Essentially, that's what the Speaker has ruled. And this is a grave, if you like, constitutional breach that has occasioned the course of action that the majority leader took to the court. And you and I know that if anybody alleges, Article 2 and Article 130, once you allege that an act as in small ACT, an action that somebody has done is likely to breach any provisions of the Constitution. You can invoke the Supreme Court jurisdiction for a court to intervene. So essentially what has happened is that the originating motion, as he said, was to invoke the Supreme Court jurisdiction to intervene and ensure that the constitutional breach does not happen. Now, the Supreme Court, hearing all the submissions, took the view that, what the Speaker has done. Because, I mean, when you read it Article 99, it is not even in the purview of the Speaker to make that determination which he sought to do. And saying that he's basing that on Order 18 or something. You and I know that even the standing orders of Parliament are subject to the judicial review of the court. Standing orders of Parliament, the Justice Abdullahi case has certainly figured to the position of the law is that whatever Parliament does was a closed book into 4 versus Attorney General, GBA versus Attorney General. That was the position of the law we all knew until Justice Abdullahi, when Yoli Kolendi, who gave the lead judgment, unanimous judgment of the court, said that in Ghana, we do not practice what we call parliamentary supremacy as it pertains in the UK. In Ghana, we practice constitutional supremacy, and that's what Article 1.2 says that clearly, that the Constitution is the fundamental law of the land. And any law, including standing orders of Parliament, that is found to be inconsistent with any provision of the Constitution, shall to the extent of the inconsistency be void. So essentially, it is only the Supreme Court, of course, once we are talking about Constitution, it is only the Supreme Court that has the mandate to safeguard or protect the Constitution by interpreting it and enforcing it. So if what the Speaker has said, which clearly was to determine that a seat has become vacant, and which mandate he does not have. And also, the Supreme Court also looked at the implication of the far-reaching implication of the Speaker's ruling, which is that it will deny the constituents of these 4 constituents, apart from the issue of the natural justice, which is so germane, so fundamental that you can't compromise on. As for natural justice, it is a principle that no court in this world will compromise on.
Yeah, and in fact, the Chief Justice I was in court did particularly emphasize on that. At some point, the judges had to nudge the lawyer for Afenyomakin to that this is your strongest point. You need to really expatiate on that, make that point clear, and then we can make our decision. David, what do you stand?
Okay.
So, Idi, I'll let David make this point.
So I think I agree to a large extent with Idi on the role of the Supreme Court here. The Supreme Court is the body which ultimately is charged with interpreting the Constitution. Now, where there is a matter which has been unconstitutional, it is the Supreme Court who is supposed to act. Now, in doing its constitutional mandate, it is important that the Supreme Court is able to make such interlocutory orders as are necessary for its effective determination of the matter before it. And in this instance, the Supreme Court has decided that its interlocutory power is going to be exercised along the lines of allowing these members of parliament to return to their seats. I think that the Supreme Court in acting only did what it was supposed to do. It only did what it was also constitutionally expected to do. I see, though, the argument that what the Supreme Court has done may look a bit sketchy, because indeed there are cases which have been in court for a while, which have not been heard, but then this matter has suddenly been heard. But I think you'd also agree with me that this matter has raised very interesting political questions, the likes of which we've not seen before. We see that we are, how many months? 2 months to election. And 2 months to election, we are having a change in the dynamic in Parliament. It's a very important issue which the Supreme Court has to step in. Now, Article 125 has put justice in the hands of the judiciary, and the judiciary acts for the people. So what the judiciary is simply doing is ensuring that the people's justice is protected. And the judiciary believes that it can do this by, first of all, holding the speaker's decision and allowing these people to return to their seats, and then finally making a determination as to whether or not there was a violation of Article 97. And so I think the court is well within its powers. I think the court is acting properly. I think the court is also standing up to its mandate to exercise its judicial review over anything that happens in the country, especially in relation to the Constitution.
Right. Julius, I'm going to give you the last word on this, but before that, let me hear from other Ghanaians who've been sending us messages. Your messages have been pouring in thick and fast. This one says, good evening. My name is Manfred in Accra. My question is, why were the independent candidates quiet when the argument was going on in Parliament? Did anyone stop them from sharing their views? Well, they were not in Parliament. But I don't even think that's the point about being heard. It's a formal hearing kind of a thing where you hear them and their reasons, then you can pass judgment on them. This one says, is the legislature truly independent as we read in the statute books? Is there any attempt to usurp the powers of the legislature? That's your point. This one is from Angela Inosu. It says, all that the NPP is interested in is breaking the 8. What happens if those who vote for them fall sick? And you use some words. This one says, hello, Kwaku. I'm Sam Bannerman in the USA. It has taken the CJ and her team forever to rule on the LGBTQ cases, which is dear to majority of Ghanaians' heart. But with the ruling the Speaker of Parliament gave on independent MPs, she did not waste time to constitute the court to give a ruling. That's what you say. Danso from Teshi says, so those saying that the party of which the MP belongs must first trigger the removal, who then will trigger the removal of the independent MP who is now crossing to the MPP? The constitution is meant to protect the interests of citizens, but not the political party. I see, that's a very strong point. Bismarck says, our Supreme Court is now more political than the political parties. They are faster than the speed of light when it comes to cases brought to it by some group of people, or slower than the snail on others. This is not a court of justice, cause justice is balanced and does not respect the views of all the other persons. Thank you very much for your messages. Julius, the last word on this is yours. Where do you stand on the court decision staying in the hands and really restoring the status quo?
First and foremost, before we go to that one, I would want us to establish this, that I think our friends, the MPP, must give Ghanaians some of respect. Because, for example, if you say that the political party must be the one to initiate the process of the removal of the MPP, the question I want to ask is, if the MPP had an overwhelming majority, or even let's say 2, 3, 4 majority, more members in Parliament, would they initiate this action? Yes, they will. Because they would have noticed that even if these seats are declared vacant, we will still hold majority in Parliament. The law must not be practiced or must not be applied in a selective manner. It must be genuine. It must be real. It must flow naturally. I don't think that the party must apply to Speaker and say, this our member has crossed carpet before the seat is declared vacant. I don't think so. Once the person has stepped up and filed his papers to contest as an independent candidate, the person automatically forfeits his membership of the party as the constitution of the MPP states. It's as simple as that. Secondly, are we trying to say that if the party never contest this decision, those members who are members of the MPP and members of Parliament will remain as MPs and all that? I don't think that should be the case. I think what we should be focused on, let's go back to the constitution. I'm not a lawyer, and I would want us to look at this. I think what the MPP should be talking about is, if you read Article 97H. For me, I think that the of the Constitution on 97G, 97.1 And for emphasis, I want to read this one so that we all.
Yeah, please do that and do so briefly.
Yes, I will. Just give me 1 minute. 97G says a member of parliament shall vacate his seat if he leaves the party of which he was a member at the time of his election to parliament to join another political party. Another political party. That's one section of 97G. The other party or seek to remain in parliament as an independent member.
Yeah.
So 97G gives two scenarios. If you leave the party to join another party, I don't think all the three members of parliament, how do you call it, the honorable member for Gomoa West, to whom and Amen have joined another party. They haven't. I think it's what the MPP should fighting. But for the stage, which says if he was elected a member of parliament as an independent candidate and joins a political party, by the virtue of even contesting on the ticket of the MPP, the member of parliament for Mina, who is the second speaker, have joined a political party.
Just lost the political party. I see, Julius, you have a lot of points to make there. But we have run out of time. Thank you very much. It's not easy to assemble these Avengers on the platform today. I really enjoyed David Kratos on his debut. Definitely, you're going to hear more of him on Ghana Connect. Oliver Fanyon, thank you for bringing us a very sharp guest. Thank you very much, David Kratos. Thank you, Julius Petechi. You just heard him there. Timothy Selikem Donko. It's also very difficult fishing that guy out. And then Idi Mohayuddin. It's also brilliant to have heard from you. And those of you who shared your messages, thank you very much. Ghana Connect will be back same time next week. For those of you who know, we'll be back on TV as well. You know the time. 8 a.m. tomorrow on the Joy News channel. You need to follow. We'll be broadening this issue further. And that is how we wrap up on Ghana Connect today. My name is Kwaku Asante. Andy Dusty is up next with the library. I'll see you again, same time next week.